Good evening and welcome. Thank you for joining us for the opening session of the SOS Arbitration and Dispute Resolution Center's new webinar series on international arbitration across Africa and the Middle East, developed together with Professor Emilia Onyema. So effective dispute resolution begins long before any dispute arises. It begins at the drafting table. Tonight, we look at how the choices made when a contract is written, meaning the seat, the institution, the law, the steps before arbitration, can quietly decide whether a clause protects you or fails you. This is the first of 3 sessions. We go on to dispute avoidance and then to the enforcement of awards. This is a conversation I will steer. Our panelists will come in on one another and we will leave time for your questions at the end. Do put them please in the chat as we go. So let me introduce our panel. Faris will open us tonight on why drafting is an exercise of party choice and foresight, and will close us on costs. Faris specializes in international arbitration in the energy sector, serves as arbitrator and as a UAE law expert before international courts and tribunals. He's a solicitor in England and Wales, was educated at SOS and Cambridge, and holds a PhD on the theory of international arbitration. Jean-François Tossens will take us through consent and its limits and multi-tier clauses in complex contracts. Of Hanotiau, Tossens, Goldman, and the Brussels Bar, Jean-François has long experience as counsel and arbitrator across post-acquisition, commercial, construction, and aeronautics disputes. He teaches arbitration at UCLouvain and has chaired the Arbitration Association Francarbi since 2022. Karim Ramsis brings the MENA perspective clause architecture, the arbitral steps, and the compatibility across contracts. Karim is a partner in the International Arbitration Group at Zulficar and Partners. He's qualified in Egypt as well as in England and Wales, and acts as counsel and arbitrator in complex commercial, construction, and investment arbitration across the region. And Jacqueline Waihenya gives us the mediator's view on whether escalation tires work in practice and an East African lens. A charter arbitrator and a member of the Permanent Court of Arbitration, Jacqueline is a director of the ICC Kenya, chairperson of the Institute of Certified Secretaries, and a PhD candidate at the University of Nairobi, with work spanning governance, arbitration, and dispute resolution across Africa. So Faris, let me start with you. Let's start with every clause starts at the drafting table, too often treated as an afterthought, actually. So Faris, you have made the case that this is precisely where parties hold real power and rarely use it. Why is that agency so fundamental to an effective dispute resolution clause?
Thank you, Dr. Amira, for the very kind introduction. Thank you to all the participants for being with us and to my colleagues on the panel. This is a topic that we discussed, and I had the benefit of discussing with our co-panelists at a conceptual level, because it's really where the intersection of both our understanding of arbitration and dispute resolution and our practical use of the tools and the mechanisms interact. At a conceptual level, it's ultimately and fundamentally within the gift of parties to decide how they structure their dispute resolution posture and choices. Such agency and power, as I think you indicated, Amira, often goes underutilized, under the radar, and doesn't carry the necessary weight and attention that I believe it should. And that's often for a number of reasons. First is our characterization of those stakeholders who actually have the power and agency. The late Emmanuel Gaillard, for example, referred to these actors as the essential actors. And perhaps a bit more crudely, and to hammer home the point, he mentioned that these essential actors are those that are essentially responsible for paying for everyone to be involved in the arbitral process. They are the parties, claimants, the respondents, the essential actors that drive the process, and pay the fees. It's those actors and their power and their agency to make decisions as to what's included in a dispute resolution clause that effectively drive and dominate the lifespan of a dispute. Why I say it goes under the radar is for a number of reasons. That's because that decision, often through chains of command and different hierarchies, chains of responsibility, gets passed from one professional to another. So often contracts start their lives, start life as in the hands of a contracts manager or a commercial draftsman or draftswoman. It's then put in the hands of an in-house lawyer, then potentially in the hands of external lawyers, and very rarely, in my experience, very rarely in the hands of dispute resolution specialists. The arbitration agreement is often known as or the dispute resolution clause is often known as the midnight clause, a clause that is agreed right at the end of a contract when people have, hammered out the commercials. And so again, the tendency for a lack of correlation or a lack of foresight with the choices that we make as to forum and forum design, governing law, applicable law, and so on. And in the arbitral context, seat, geographic venue, number of arbitrators, language, and so on. These things can often just become an afterthought. So to make that point clear for our participants, because I'm conscious that we've got people from different experience levels, we've got students, practitioners, and so on. I mean, to make the point clear about how sacred, how powerful, how important those choices are, I'll just briefly focus on three main intersections where there is a very direct relationship between the conceptual and the practical in making those choices.
Okay. Faris, while doing this, could you please also explain to us what do parties most often fail to anticipate when they draft?
I think that's a great question. And I mean, that's inherent in the points that I wanted to raise. So it's each of those points, the ones that I will raise are things that parties tend not to consider. The first is the heightened nature of the choice between courts and arbitration and what that actually represents. The traditional decision between courts and or arbitration is actually a decision of usurpation. It's a very violent decision in many senses, where you're taking jurisdiction away from one decision-making body and giving it to another. And when you transfer into an arbitration agreement, what you're essentially saying is that a national court or an international court in the current circumstances, as is increasingly the case, does not have jurisdiction over my dispute. I, as a client, will manage my dispute. I'll be in charge of the process of nominating and appointing my decision makers, of structuring the forum and the design of it, the language, the procedure, and so on. So that's a fundamental decision. Now, there's a lot of competition between courts and arbitration. And what often goes underlooked, and you're saying what the clients overlook, is when they make a choice of one or the other, they don't consider the symbiosis when they make the choice for arbitration. So even when you make the choice for arbitration, you haven't completely extricated yourself from the court system of national court systems or international courts. You still have the role of the supervisory court. You still have, after the arbitration, to consider enforcement courts, national courts, and so on. So, I mean, that's a fundamental relationship that I think parties should bear in mind, often don't bear in mind. Have you got a question, Dr. Amira? Is there a question you want to raise?
Yes, I was asking if you have any remark considering, where parties often fail to anticipate. Do you think that this is like a practice of in-houses because they try to avoid disputes so that they don't pay much attention to the arbitration clause? Or it's just by they are not just they lack the knowledge to do so.
Well, I don't think it's a lack of knowledge. In my experience, I think in-house counsel, depending on their focus, their level of experience, they will often be using templates and often be relying on external counsel. So actually, the decision often will fall to lawyers who are outside of an organization. And then you have a question about what their interests and what their knowledge are. Are their interests in situating an arbitration clause or a dispute resolution clause in a jurisdiction or in a forum that suits them, that they feel comfortable with as a law firm, if it's an external firm? And where does their knowledge base extend to? How willing and flexible are they to incorporate foreign legal systems, foreign practices, and foreign processes? The second point that I wanted to get to was about the questions of forum design, applicable law, seat, and so on. I mean, there's so much to say here, but the point I wanted to make is that there is a very direct correlation between the applicable law that's chosen for a contract and the seat of an arbitration, and actually the counsel and the arbitrators that end up being involved in a dispute. And that's often something that parties do not anticipate and do not necessarily have a full understanding of. So it's all fair and well for parties to contract in different environments, perhaps in a regulatory environment in the Middle East or a certain part of Africa. And then, when it comes to the dispute resolution clause, if you've chosen Paris as a seat, for example, in an arbitration, if you've chosen English law, or if you've chosen an institution like the LCIA or the ICC, the chances are that unless you work very, very hard in some senses, and are very particular about your choices, that you will end up with certain practitioners that are from a certain tradition. And that can have a number of consequences for the way that the dispute is handled, managed, particularly on questions of applicable law or regulatory frameworks that are in the place where the contract is being performed. So, I mean, there's no one size fits all. It's a very particular process, and I mean, it's fraught with difficulty. But I think these are questions that clients should be asking themselves fundamentally.
Would you say that the parties most oftenly fail to anticipate what is related to the applicable law in general in this in the clause? Because there are many parameters, but if you would name one, would you say it's the applicable law?
Not necessarily. I think that there is the issue with applicable law, in my experience, tends to be not necessarily understanding how taking an applicable law out of its national linguistic context can impact the way in which issues are pled and decided on when that takes place. Take, for example, UAE or Egyptian law. If you have an English language arbitration and the applicable law is Egyptian law, I mean, obviously, you are then likely, by virtue of the fact that you have that, you've opened up the fact, you've opened up the arbitration agreement to be in the English language. You'll have practitioners who are not necessarily Egyptian, for example. And so that's a hurdle that some people, again, that might be something that people welcome. They'll say on neutrality grounds, if there's a particular nexus in the contract to Egypt, they'll say, I prefer not necessarily having Egyptian nationals or Egyptian lawyers working or actively in different positions on the arbitration, either in the capacity as arbitrators or in other positions. But it's that duality that I think people need to consider, because what they believe may be in their favor or may relate to a particular industry context or regulatory context, once you take it out of its linguistic context, has a different meaning.
So we can say that they should consider the consequences that may apply culture and also the language aspect of the dispute, and eventually the practitioners who may be involved in it. So very interesting, Faris. And if drafting is an act of deliberate choice rather than habit, the first question is whether the parties truly agreed to arbitrate at all. Jean-François, would you want to explain to us from your extensive experience recently? I know that you had also a case regarding the question of the maître d'ouvrage problem. A contract carries on arbitration clause, yet it's not always clear if the owner itself consented. So why does that matter at the drafting stages?
Thank you very much. First, let me say it, my pleasure to have been invited by Dr. Amira Mahmoud and Professor Emilia Oneima. It's a real honor and pleasure to be among you today, and it echoes my particular interest for Africa and MENA regions. So I'm particularly delighted to discuss these topics, these very thought-stimulating topics with you. Yes, as you say, the Amira consent is definitely the cornerstone of arbitration. Arbitration is party autonomy. Party autonomy is consent. You have no arbitration without an arbitration agreement, and you have no agreement without consent. So consent is the basis for arbitration. This is also why it's one of the most frequently disputed issues when one party, for various reasons, tries to escape from arbitration proceedings. They will obviously tackle the issue of consent if they can. That's why consent is also an aspect that is frequently discussed. It's already the case generally as soon as there is some lack of clarity in the arbitration agreement, but it's especially the case when it comes to the extension of the agreement, of the arbitration agreement, to non-signatories, because by definition in that situation you don't have an explicit consent to a particular set of proceedings. Then you need to look for consent through other routes, and that's the issue of implied consent. So I will not make a general theory or overview of the extension of arbitration agreement because it would take, of course, much longer than the frame of this seminar. But I think it is fair to say, to summarize that in most, if not in all cases, consent remains at the basis of any extension of the arbitration agreement. There's lots of arbitral awards, famous arbitral awards. There's lots. French case law has been especially developed in terms of defining from which factors consent may be presumed to extend an arbitration agreement. It has influenced national laws, especially, for instance, just as an example, in South America. Anyway, there's a whole theory about how you would identify consent through a set of facts. Usually, you would not just be satisfied with one single element, such as the involvement of a party in the implementation of the contract. This would be, of course, a very relevant factor, but it would traditionally not be seen as a self-sufficient factor if it's not evidencing a consent to be part of this agreement, to be based on a general analysis of the circumstances. Also, the group of contracts is in itself is not a sufficient circumstance to decide that consent is among all components of the group to arbitrate in one single arbitration. So I will, as I said, I will not go much further in the description of the theory, but the search for consent is really at the heart of any extension of the arbitration agreement, extension to, of course, that is geared by considerations of procedural efficiency, because one main downside of arbitration towards court proceedings is that usually you are limited by the privity of the arbitration agreement, even in circumstances where you would have an objective interest in extending the scope of the proceedings to other parties, such as in complex construction contracts. So what I would just want to highlight today to stimulate the ensuing discussion is the tension that may exist beyond this traditionally accepted principle that implied consent should be found somewhere, that is required. But how do you look for this implied consent in some specific circumstances where you can have some sort of tension or a conflict between the procedural approach and the jurisdictional approach? Procedural approach based on considerations such as the procedural rules that are applicable, procedural efficiency, while traditionally, you would, for the jurisdictional approach, you would really need to have a look at the actual consent of the parties, irrespectively of the procedure itself. And here is my example. That is an example that's based on a pending ICC proceedings. I will, of course, keep it anonymous, but it's fairly classic and relevant, I think, for the discussion of this tension I was mentioning. There is a construction contract between, there's one main contract between the owner, Maître de l'ouvrage, as you called him, Amira, and the main contractor. This is, in this main contract, there is no reference to subcontractors or to at least to a subcontract. The main contractor is declared responsible for everything that can happen below him. And of course, but everywhere is aware that there are subcontractors, and in particular in this case, it's a very important part of the project that is implemented by subcontractors to 70% of the project, and these subcontractors are effectively involved in the implementation of the contract. Of course, the clause is a standard ICC clause. With broad terms, any dispute arising out or in connection with you. We all know these clauses. Then you have a subcontract between the main contractor and subcontractors, a number of subcontractors, which is actually the mirror of the main contract, with many references to the main contract, and with an identical standard ICC clause, with also a broad definition, disputes arising out of. But these arbitration clauses do not specifically address the issue of multi-party arbitration or of joinder or consolidation or whatever. They are just similar, mirroring each other, but they do not mention the potential extension of the proceedings. So what happens and what was the issue is that the main contractor files a request for joinder against the additional parties in an arbitration that is initially initiated by the owner. So the additional parties dispute from their perspective the joinder. The joinder is accepted by the ICC, and now it's up to the arbitral tribunal to decide on its jurisdiction. Because what is important to understand is that the decision on joinder does not imply automatically a decision on jurisdiction. This is the first distinction that needs to be made, and the jurisdiction is in the hands of the arbitral tribunal. So after the procedural decision of joinder, there's still a decision on jurisdiction by the arbitral tribunal, and this is explicitly said so by Article 7 of the ICC rules before for former version. So what are the positions here? The main contractor, the claimant for the joinder, says, well, there is consent. There is an implied consent of the owner. Why? Because they elected to have the arbitration conducted under the ICC rules, and ICC rules contain Article 7, which mention a potential joinder, and the clauses are identical. It's even more than compatible, they are identical. So, and there is, of course, considerations of procedural efficiency. It's going to be much more efficient. We will avoid contradicting decisions if it's one single arbitration proceedings between the owner, the main contractor, and the subcontractors. Well, the owner has a completely different view. He says, no, I have not agreed to extend the arbitration agreement. And Article 7 is just about procedure. It should not be interpreted as implied consent on my side to have this initial arbitration agreement just between me and the main contractor extended to additional parties. This is why I resorted to this closed contract, even though I knew that there would be subcontractors. This is part of my interest, of my reason to resort to arbitration, is to have a closed, confined arbitration proceedings, obviously to avoid more complexity and more delays and more cost in discussing who's responsible for what problem. I have a main contract. The main contractor is responsible for everything, period. That's all I want to know. I don't want to make things complicated. So you have a conflict between two procedural efficiencies, and you have a conflict, from different perspectives, and you have a conflict about from where can you look for implied consent? Are the procedural rules a relevant source for looking for the implied consents in absence of explicit organization of a more extended proceedings? So the result is that it's 6 to 8 months delay for additional dispute, hundreds of thousands of dollars of additional costs, just about the jurisdictional issue, and several legal experts involved, and so it's of course a real increase and delay in itself. So why I think it is interesting, I think it highlights that there can be a tension because, as I said, procedural rules and analysis of the extension of the arbitration agreement from a substantial aspect of the consent. Is there a right to privity of arbitration for the parties to the initial arbitration agreement, even though they have resorted to procedural rules that organize potential extensive proceedings with additional parties? And finally, a very practical consideration, again, which echoes what Faris said, please just tailor your arbitration agreement the way you really want it functions. And just do not satisfy yourself too easily with an arbitration agreement that seems all right, but that maybe does not encompasses all your practical concerns, especially in complex construction contracts where the issue of potential extensive arbitration will probably arise. So do organize this in your arbitration agreements. That's what I would like to say as an introduction to this subject.
Exactly. But I would like to ask you, how far do you think consent should reach? To the third parties. And regarding this, for example, if we take the Article 7 of the ICC, do you think that should institutional rules be able to bind a party over another's objection, for example?
Well, as I say, it's a little bit a matter of. I think everyone agrees on the fact that then there is a need for consent, and on the fact that in some circumstances you can look for consent beyond the explicit terms. So I think, especially in complex situation, and there is a possibility for joinder. But then then where do you put the cursor?
Yes, exactly.
That's the issue.
Where do you put it?
Personally, well, this is a personal view, but there can be other views, and all together, it's a matter of interpretation of the parties' intent. But in my opinion would be that in absence of a clear intention, if a party chose to confine the arbitration agreement between a limited number of parties, such parties should have the right to keep it confined, irrespectively of of potential extensions. But these procedural efficiency considerations, if any, should never overrule the need for consent, because consent is really the basis for all arbitration, and consent is not only consent to arbitration in itself, it's consent to a perimeter in terms of parties involved and in terms of subject of legal relationships involved. So I think you should recognize the right for a party to confine the scope of arbitration to the limited number of parties it elected to do initially. Of course, then it's a matter of interpretation.
Because as Faris has highlighted before, usually in this kind of projects, we have many contracts together. It's a chain of contracts, and it's not always the same persons or the same in-house or lawyer who is following up on the same project always. So sometimes it's just not really the consent, but just unawareness of the results. But the point is clear, and this also reminds me of what you have been saying about the dense drafting of an arbitration clause that may end up obstructing the very arbitration itself that it was meant to secure. So the drafting in general is a very crucial moment, and we shouldn't underestimate the consequences that may fall, especially in this kind of contracts where we have a multiple chain of contracts. So we have asked whether the agreement to arbitrate holds. Now let's build it. So Karim, are you here?
Yes, thank you very much, Amira.
I just wasn't okay. So what are the essential elements parties should be deciding when they draft, and what is distinctive in the MENA region and administrative contract content?
Thank you very much. It's a great pleasure to be here, and I'm grateful to you and Professor Onyema for your kind invitation. So just as a general overview in response to the question you have posed. So when it comes to the content, or let's say the building blocks of the arbitration clause, I think the starting point is that it should not be treated as boilerplate. As highlighted by Faris, the parties often devote considerable time to negotiating the commercial provisions of the contract, but comparatively little time to considering whether the dispute resolution clause is actually fit for purpose. Yet, once a dispute arises, it often becomes one of the most important provisions in the contract. It shapes the procedural framework within which the dispute will be resolved, and if not carefully drafted, can give rise to procedural objections that may distract from the substantive issues in disputes. So at a minimum, I would say that the arbitration clause should clearly address the seat, the applicable institutional rules, the language of the arbitration, and the number of arbitrators. The seat is particularly important, and of course should not be confused with the hearing venue. The seat determines the procedural law governing the arbitration, the courts exercising supervisory jurisdiction over the arbitration, and of course the courts before which any application to set aside the award would ordinarily be brought. There's also an important point concerning contracts involving public entities, which I think is something that is a bit specific to the MENA region. In a number of jurisdictions in the MENA region, arbitration agreements involving public entities may be subject to specific approval requirements. These are not mere formalities. If the required approval is not obtained, the arbitration agreement may later be vulnerable to challenge. One example is the Egyptian arbitration law, which provides that arbitration agreements in administrative contracts require prior approval by the competent minister or the official assuming the minister's powers. This often arises in construction and infrastructure projects involving governmental or public entities. The practical difficulty that I would highlight is that parties may not always appreciate at the drafting stage that the contract may later be characterized as an administrative contract under Egyptian law. So before finalizing the arbitration clause, Counsel should consider whether the contract is one that attracts any statutory approval requirements. And if it does, the Counsel should make sure that those requirements have been satisfied and properly documented. So taken together, these are not simply drafting details, but they define the legal framework of the arbitration itself. The clearer those choices are at the drafting stage, the less likely the parties are to find themselves litigating procedural issues instead of the merits of the dispute.
Do you think that drafting parties in general do it on purpose just to avoid the hassle of the negotiation on something they may not use? And they do not like to lose. I know that in-house in general they really try to avoid, but this we'll talk about extensively in the second session. I think here also where many things can slip away from the drafters, and this is also the natural home for your point, Jean-François, on the difference between the law applicable to the agreement, the arbitration agreement, and the applicable law in general. And I think that this is a very subtle difference that usually drafters do not pay attention to.
That's a fair point. I'm sorry if I may, John. I'm not sure if this question is addressed to me, but just one quick point on that.
You can discuss it, both of you.
Yeah, just a quick point on that. And I of course, this touches on a point that Faris has mentioned earlier with respect to the involvement of external counsel. So during the drafting stage, external counsel is typically involved. However, those lawyers are typically transactional lawyers and not specialized dispute resolution lawyers, and therefore things go wrong quite often. So that's my take.
Jean-François, what do you think? Why must this question of the difference between, for example, as an example, but a very relevant example, the difference between, for example, the applicable law on the contract as a substantive law and the law applicable to the agreement matters, and why it must be addressed at the drafting stage?
But actually, the natural trend of people who have never come across that sort of issue would be to think that because they have chosen a law applicable to the contract, this law will be applicable to all aspects of the contract, and including the arbitration agreement contained in the contract. So that's, to be honest, that's one of the main criticism that is put forward against another approach that would consider that the law applicable to the arbitration agreement can be determined by the seat of arbitration, even though the law applicable in the contract is another law. And you know, there is a famous case where French courts have adopted diverging views compared to the English courts, and especially in particular in a case where it was about extension of the arbitration agreement. So can you imagine a party that is not even maybe completely aware, or it should if it consented impliedly, but a party that were more or less party, sorry if I say so, because precisely it was the discussion, to an agreement that was extended to it on the basis of a law that was not even the law of the agreement. So this is something you need to be aware of. This is while, of course, the best case is that you consciously choose the law applicable to the arbitration agreement. Usually, it is very often the same as for the law of the contract. But be aware that in some countries, such as France, for instance, the courts would, especially in context of extension of arbitration agreements, consider that this is the law in absence of explicit choice by the parties should be the law of the seat of the arbitration, in this case, French law. And then this is the whole concept behind about implied consent and extension to an arbitration agreement, which of course can be viewed more strictly from other jurisdiction, such as England, UK, for instance. So
the Corsica new rules also, they are following the French position, as Karim has highlighted.
And more in general, the importance of the this is another example of the importance of the seat of arbitration, of the choice of the seat of arbitration, as Faris and Karim have already said. And it's not only about the applicable law, but it's also about the scope of review of the courts of the place arbitration. To what extent will these courts actually go into the review of the jurisdiction issue? Is it a full de novo review of the issue? And what's their case law? So choosing a seat is also choosing the courts that will be competent for reviewing the issue of jurisdiction if this issue is challenged by the parties to the arbitration proceedings.
So maybe it's better to have to highlight the three applicable law. Actually, the substantive law, the law applicable to the arbitration agreement, and the seat, because it will be the law of the procedures. This is the ideal scenario.
Well, in many cases, the law applicable to the contract will be very different from the seat, especially, for instance, English law is everywhere.
But if you explicitly mention in the contract, that the applicable law to the you specify the applicable law to the arbitration agreement, you don't have to deal with this issue anymore before any national court.
Exactly.
So this is maybe
the more the clearer you are, the less problems you will have in case of discussion.
But not that when we say clear, it doesn't make it heavy. So to keep up with the first remark concerning the pathologic clauses or agreements where it's very heavy and you just can't follow with it, and it leads to instead of protecting the whole arbitration process, it ends up by an obstruction of it. Karim, Jacqueline, I don't know if you have any word to add on this matter, or Karim, on the difference between the applicable laws or the content, the blocks of the clause itself.
Just one point from me, Dr. Amira, if I may.
Of course.
And this is just, again, for people of various professional backgrounds and stages in their careers. I haven't got cameras on and I'm not familiar with the names, so forgive me. But I mean, one point to just hammer home is that these issues that we're talking about, if you fail to be particular about them, if you fail to articulate them, as Jean-François says, clearly, or as Karim put it, in very delineated terms, giving a blow-by-blow rendition or rundown of what your choices are, the practical consequences of this are conflicts, challenges, ending up in court when you should be in arbitration, wasting time and wasting money. Okay, that should be the driving force. I mean, put it in another way, Dr. Amir. I mean, I'm sensing there's a bit of a casting of a shadow over the qualities of in-house lawyers. I mean, in-house lawyers actually, as part of their mandate, have risk management and conflict management within their ambit. It's actually what they're set out to do as part of their fundamental mandate. And I think that's very important for in-house counsel to recognize and to take control of, that by making these choices clear, they're actually avoiding problems, avoiding wasting time, and avoiding wasting costs.
Exactly, and this is the purpose of the whole session, to be aware of these details with professional people who have the experience of this kind of projects, because actually most cross-border contracts do not go straight to arbitration. You have layers, and this is where maybe we can this question can lead to the layers and steps first. So you can actually have steps before you end up into an arbitration. So there are multi-tier clauses that could be drafted differently, and the stages should generally connect. So Jean-François, maybe you have something to say about this, about the connection, and how can we connect the multi-tier clauses together rather than tripping each other?
My pleasure again. Thank you, Amira. Yes, regarding multi-tier dispute resolution clause, I think it's going to be another example of the need for clarity and of the backfiring effect of some uncertainties that you can find there. So generally, I think it's fair to say that multi-tier dispute resolution clause have become much more frequent than before. I think compared to like 20, 25 years ago, I would say that it was maybe the exception, or today it's the exception to have an arbitration clause that does not refer at all to any sort of alternative dispute resolution mechanism at some stage or some level. And we all agree that the ADR mechanism and especially mediation are a great tool to solve disputes, and that there is no better solution and no better outcome than an amicable settlement. And we all, as as practitioners, we are all involved in pushing towards that sort of approach. In Belgium, for instance, it's even in the law now as an obligation, as a duty for not only for the lawyers, but also for the judges. And so arbitration is part of that trend, and definitely ADR mechanism and especially mediation are definitely tools to be encouraged to expedite and to have an amicable solution rather than a lengthy and costly dispute. This said, again, so the purpose is not to blame anything on the ADR mechanism and mediation. But this said, of course, when you organize things in advance, then you get into the same sort of issues about interpretation, and when people are quarreling, are in the middle of a dispute, they don't agree on anything anymore. So you get to have issues about the implementation of these alternative approaches to some extent at the same level as the disputes on the substantial issues. And what kind of issues can you have in terms of regarding these clauses? Well, these clauses are part of the contract. So they must be respected, though they have the same force as any other provision of the contract. And then you get confronted with issues such as, have they actually been implemented? Meaning, have there been sufficient efforts from both parties or from one party to actually try to find alternative ways to solve the dispute? has the timing been respected in these different stages? And if there was a lack of implementation, if there was a default by any of the parties in implementing these preliminary steps, what's the sanction? Is it a problem of jurisdiction of the arbitral tribunal? Is it inadmissibility of the request for arbitration? Is it just, which is generally the case nowadays, I think, just a suspension of the arbitration proceedings? It's even explicitly said so, for instance, in Belgian law. It's just a matter of suspension also before a court. But what's the discretion of the arbitral tribunal? All this to say that it's yet it may raise a number of issues, and like for other issues that we have addressed, it may cost a lot of time and money before you get there, and you get to a result that is exactly the contrary of the initial objective of these clauses, which was to favor an expeditious and amicable settlement of the case. So when it gets nasty, these clauses can be a dispute in the dispute and can add time and cost and frustration, because it's even more frustration. It's even a bigger frustration to have an issue about a clause of which very purpose was to put people together.
It raises also the question, sorry to cut you, but maybe this would resonate with you. It raises the question of the difference between admissibility and jurisdiction, actually. So you have to, like you said, it will be a dispute in a sub-dispute in the dispute.
It's the subject where that it can be that sort of conceptual differences and discussion about admissibility, jurisdiction, and can depend on, yes, on the arbitral tribunal, can depend on jurisdiction. Just to give you a quick flavor of the discussion, I was participating in a workshop with 30 seasoned practitioners, arbitrators, about this very specific subject 3 months ago in Geneva, and so we were discussing the pros and cons of these clauses in practice. And while everyone was in favor of attempts to be made towards amicable solutions, they said, on balance, well, they would rather recommend not to write these sort of clauses if you are not sure that it's a very efficient, clear, and straightforward clause. So the price to be paid to unclear clauses is probably higher on balance than the benefit that you can expect from them in a fair and speedy implementation. So that was just the feeling of the panel of 30 experienced practitioners. But I will just finish maybe just this introduction on the subject matter by another warning that is more specific to what we call third-party binding decisions, some sort of intermediate layer between what you call mediation and full-fledged arbitration. The typical example would be the DAB in complex construction contracts. So again, these mechanisms are extremely helpful and sometimes inevitable in complex situations such as construction contracts or joint ventures, which is another example where these intermediate mechanisms intervene before you can resort to a full-fledged arbitration. And there is another kind of issue, which is the hierarchy of the decisions that such third-party binding advisor will take, and the later arbitration process, fully jurisdictional process. Is it binding to the arbitrators or not? And it was a subject that was discussed in the same workshop I mentioned earlier, and it was quite amazing to see the nuances, if not the divergences between arbitrators coming from very neighboring countries such as France, Switzerland, and Belgium, with different concepts. And again, it can be organized, and then you don't have these issues if everything is clear in the contract. But in many instances, again, the slightest lack of clarity will raise that sort of issue. And one final maybe example If you give me just 2 minutes just to illustrate. Yes.
2 minutes will be a lot.
Pardon me?
1 minute.
1 minute. No, just in a joint venture, there was that sort of mechanism, but that was so complex, and it was the mandatory preliminary before resorting to arbitration. But you have all sorts of different board reserved matters, and in case of a dispute, you needed to follow one of these routes before resorting to arbitration. But it was so complicated that parties quarreled for months to know in which hypothesis they were before resorting to arbitration because of this preliminary that was mandatory. And again, that illustrates Faris' points. You should, when you draft contracts, you should have a stress test by people who have experience in dispute resolution, because many of these contracts, complex contracts, are drafted by people, internal or external, who are corporate, experience from a corporate aspect, but they have no personal experience of dispute resolution. And then that's what's happened.
Thank you, Jean-François. And for this, maybe Karim had very quickly something to say about the comparison concerning the pre-arbitration steps and the DAB mechanism, how to draft them to avoid later admissibility objections, if you have seen or any differences comparing to what Jean-François was explaining in the European context.
Right. So I agree with Jean-François that pre-arbitral steps. I'm sorry?
You have two minutes, Karim.
Yeah, sure. Less than 2 minutes. I'll try. So I agree with Jean-François. Pre-arbitral steps can be highly effective in resolving disputes before arbitration, but only if they are drafted as workable procedural mechanisms rather than vague aspirations. So this could be by way of amicable settlement discussions, senior management negotiations, mediation, expert determination, or referral to a dispute board. The difficulty is that if they are not carefully drafted, they can themselves become a source of procedural objections. So turning to the DAB or the DAAB under the newly issued FIRIC forms of contracts, these forms of contracts provide that disputes are required to be referred to a dispute board before arbitration may be commenced. In practice, however, difficulties frequently arise because no board has ever been constituted. The parties may never appoint the board. One party may refuse to cooperate in the appointment process, or the contract may fail to identify a workable appointing authority or an appointment process. So when a dispute then arises, the claimant wishes to proceed directly to arbitration, while the respondent argues that the claim is inadmissible because the contractual precondition has not been satisfied. So obviously this creates a difficulty. The contract requires referral to a dispute board, but there is no functioning board to which the dispute can realistically be referred. So what matters is that the clause anticipates that possibility. It is not enough simply to require referral to a dispute board before arbitration. It should also provide a workable solution if the dispute board mechanism cannot operate in practice. So the broader point is that pre-arbitral mechanisms should be drafted to facilitate the resolution of disputes rather than create unnecessary arguments about whether arbitration may proceed.
Okay, so
Dr. Amira, can I just add one point before we go to the Q&A? And this is
no, we haven't finished because we haven't heard Jacqueline until now. Jacqueline, we're still here in the same on the same question. We heard the litigators, we heard the drafters, and we'd like to hear the neutral part. So Jacqueline, you sit as arbitrator and mediator. Do these layers or pre-steps work in practice, or do they mostly create procedural traps and delay?
Okay, thank you so much, Dr. Amira, and it's great to also sit alongside my fellow panelists this evening. You're correct in noting that I do sit as an arbitrator. I'm a chartered arbitrator, and I'm also a chartered mediator, and I also am a construction adjudicator. So I do happen to be in all these spaces. And I also have a background in governance. I'm a governance expert. So when it comes to drafting and the approach from the transactional perspective, I think the first point is to recognize that not everybody approaches drafting a dispute resolution clause as a strategic governance imperative. Most times, I tend to think that most transactional lawyers and corporation secretaries tend to be very optimistic. They expect that the dispute resolution clause is not really going to kick in, and they expect that everything is going to flow. Unfortunately, when there is a dispute, and this is the mediator in me speaking, the first point I usually want to make to any of the parties is that when we're drafting the arbitration clause, it's not really thinking about where the parties will land if they fight. And I think the adversarial aspect tends to be highly emphasized when we're looking at the whole dispute resolution process. I like to emphasize that the dispute resolution clause also needs to be a tool to ensure that commercial relationships will survive even when the disagreements would inevitably arise. And that is where I usually like to start with the, whether I'm teaching or whether I'm also engaged as a practitioner in the dispute resolution process. And of course, because we're talking about arbitration, mediation tends to come as part of the multi-tier clause. And the first thing I think the most important thing is that we need to get to the parties to think through the dispute resolution clause so they can negotiate in good faith from a position of knowledge. This doesn't tend to happen a lot. They overemphasize a reality that seems to indicate that the parties will want to ensure that they get to the finishing line. They close the contract and they move on to something else. Unfortunately, in reality, even commercial relationships, though we try to make it difficult to perceive it differently, they do become emotional. And when there's a dispute, sometimes the positions harden. And I'm speaking about this because mediation tends to be a fairly different approach to dispute resolution, because we are calling in the parties and telling them, look, I'm here as a third party neutral. I wasn't there when you drafted the contract, but I'm walking you through the potential to resolve this dispute before you have to go into an adversarial process. So I tend to work through them, not looking at the question of who is at fault, or who made where the problem arose. We are trying to get them to think about what is their interest, what does the future look like, and where is this future going to take you to, so that we can be able to quickly resolve in an efficient manner. Including when the lawyers are involved and the positions are hardening. And there's a lot of pressure because almost always there's a lot of money on the line. So human contemplation, behavior, emotions tend to come into the process. So we, from the mediator's perspective, and this happens in East Africa, it's happening in Africa as well. I had the opportunity to sit with the Chief Justices. Actually, they call themselves the Africa Chief Justices ADR Forum. We had 22 Chief Justices in Kenya about 2 weeks ago. And in addition to this, we also had 40 leaders of different judiciaries from around the continent. Around 40 jurisdictions were represented. And their feeling is that they want to move away from the hardcore adversarial approach. And in Africa, basically, this was the feeling, and this was expressed by almost all the members of the judiciary, is that they are investing, and they are going to invest in quarter-next mediation. So we can expect that mediation will get a bigger platform and a bigger voice. So this is the tendency. This is where everybody is going. And I'm going to call it a myth, because we tend to have this myth that mediation is going to unlock commercial flexibility. All you need to do is to bring in the parties into the room, and you walk them through 60 days, and they'll be able to come to a resolution. But from a procedural point of view, there are many issues that we don't tend to think through, and this is what I would probably want to propose from a commercial perspective. It matters which countries the parties who are entering into a contract and drafting the dispute resolution clause come from. If it's East Africa, we already have a region, and there is a legal infrastructure that informs even the infrastructure projects, PPPs, energy, logistics, and even the after implementation. And digital commerce is also a big deal. And also in East Africa, we have about 3 regional economic communities. And I'm sure in North Africa, SADC also has the same challenge. And when you talk about public entities, I think Karim talked about getting the approvals, statutory approvals. This also tends to apply also when it comes to mediation. And if it is a private institution, even the boards of directors also need to bring in their approval. Now, the challenge with mediation is that when you come to mediation and you're working through the mediation process, even if it's just a private institution, you find that what tends to happen is that the people who have the decision-making power are not always in the room. So they will be asking, they'll be telling you, look, in principle, we agree, but we have to get a board approval. We have to send it back to our board of directors. If it's in the public sector, it's the government, there's a ministry, there's a department, there's an agency. So ministerial approvals, and then of course, different jurisdictions have different approaches to procurement compliance. So there are very many opportunities to fail at this point if there wasn't sufficient thinking through how the dispute resolution clause will also come in. And then Karim spoke about the DABs. Those are under, I think FIDIC has really tended to adopt this. But in reality, there are many contracts, and PPPs will have multiple contracts for a single project. It might be EPC, it might be financing, it might be insurance, there's operations, there's maintenance, there's consultancy, there are subcontracts and subcontractors, and there are so many different dynamics, moving parts that can create parallel proceedings just from one disagreement. And I will also mention the question of ad hoc and institutional, institutional dispute resolution, and the way many African countries have adopted either ICC or LCIA, and there's now a move to localize it into African jurisdictions. So what I'm basically trying to describe is we can have a veritable cocktail of what could come through. But okay, I could stop there, and if there's any other comment.
Go back to widen the lens through the African lens, but before moving to this, because you highlighted the complexity of contracts and you were referring to what Karim has said, and exactly that brings us to a different drafting challenge once we move beyond a single contract and look at an entire project structure. So how can parties, Karim, ensure that their dispute resolution clause remains compatible across the contractual chain, and then not to end up generating parallel procedures or inconsistent outcomes? I think you have something to tell us about this, but really briefly, because we're running out of time. And then we'll go back to Jacqueline to have the East African vibes, and Faris, I didn't forget about you.
Yeah, there's no real answer to whether it is possible to make all these moving parts move together. And one of the problems that we're having with the multi-tier contracts is that we're making mediation mandatory. We're saying go negotiation, go mediation, then maybe if you haven't resolved, then you can go into arbitration. So there needs to be a lot more thinking about how we are drafting. Yes, yeah.
this was a question actually addressed to Karim about the compatibility across the
sorry about that
chain. But you will have your takeaways to give us after he finishes.
So very briefly, Amira, and I think this is a very important issue. Personally, I have been involved during the past few years in two high-profile arbitrations involving multiple contracts, or multi-contract arbitrations, let's say. So I think the issue here is that now one of the practical issues we encounter is having a project, for example, a subcontractor concluding several subcontracts with a main contractor in relation to the same project. So this issue has become common and prevalent in the region. The difficulty arises where those related contracts contain arbitration agreements that are not sufficiently aligned. They may provide for different institutions, seats, or procedural arrangements. So at the drafting stage, those differences may appear insignificant. However, once a dispute arises, they may prevent closely connected claims from being resolved in the same arbitration, requiring the parties to pursue parallel proceedings instead. That, of course, can result in increased costs, procedural inefficiencies, and inconsistent decisions as well. So modern institutional rules, including regional institutions, increasingly provide mechanisms to deal with disputes arising under multiple contracts and to consolidate related proceedings. However, those procedural tools are only effective if the underlying arbitration agreements are sufficiently compatible. If the parties intend disputes arising under related contracts to be brought in a single arbitration, that intention should ideally be made express. At a minimum, the clauses should be aligned on the institution, the seat, the language, tribunal composition, the scope of disputes, etc., covered by the clause. So I think the key takeaway here is that where multiple contracts relate to the same project or the same economic transaction, the underlying arbitration agreements should form part of a coherent procedural framework that supports the efficient resolution of related disputes.
Okay, thank you, Karim. So let's, to build on this, let's widen the lens. And so we have an Eastern African practitioner. We have Mina from Egypt and UAE/Palestine. And we have the European position. We know about your position. You have mentioned what you think in a very technical way, Jean-François. But so let's go back to Faris and Jacqueline and eventually Karim. Where do these challenges look different from where you sit, each of you? All the challenges we have mentioned, where do these look different?
So, I mean, firstly, I'd like to thank Jacqueline for her brilliant intervention and contribution. And I think she touches on things that really bring together the various issues that we've been talking about. She actually summarized it in quite a nice way. And she triggered an idea which I'd like to convey to the participants. And that's really that there's a trend at the moment that we're facing in arbitration towards, some say judicialization, some say they call it the complexification of arbitration. You know, it's increasing, definitely increasing in cost, definitely increasing in time spent. And one of the pushbacks to this that we're seeing, so that's a process that's been happening, I would say, for the last 20 or 30 years. And one of the pushbacks that we're seeing is, as Jean-François put it, the tendency towards mediation, as Jacqueline and Karim put it, the tendency towards using dispute resolution boards, DABs, and so on. And you can see in the most recent iteration of the ICC rules, I urge people to go and look at this. They've now got the expedited procedures and the expedited provisions. And you can see, for example, I think it's in Appendix, let me just get the exact appendix to direct people to it. Appendix 5 of the newest edition of the ICC rules 2026, expedited procedure provisions. And if people look at Article 1.3, they can see there that the threshold amount has gone up from 2017 to 2021 to 2026, from $2 million to $3 million, and now most recently in 2026 to $4 million. What's that saying, essentially? That's saying that incrementally, the institution will take decisions out of the hands of the parties to make sure that things run smoothly. And so fundamentally, that issue of party autonomy and taking decisions, if it's not done by the parties, increasingly, it will be taken, those decisions will be taken by other institutions, by other people, and people in different places, and perhaps with different interests in mind, perhaps not competing interests, but different interests. And so that's something that I think we need to consider as a community. And Jacqueline made that point very, very well.
Yes, and this also refers to what you have been saying about the costs recovery and what are the downside, for example, of some institutions, among them the ICC, regarding this matter, maybe on how should that shape a forum design. Maybe Jacqueline, you could help us with this. Also Faris, about the recovery, the cost recovery. This is a direct consequence of what have you started with. So let me bring us back to where we begin, to the consequences parties do not anticipate. Jacqueline.
Okay, I think the first point I think everybody needs to appreciate is that each dispute resolution clause needs to reflect the type of subject matter that the parties have gotten into, and also where the performance is going to be done, and to appreciate that there's always a risk. The more autonomy you give to the parties, the greater the cost, the price. There's a price to everything. So we must emphasize and let the people know when you're engaging into a contract, and of course the dispute resolution clause is part of that, is that somebody must be given the responsibility of solving every procedural problem. Because this is where many multi-tier dispute resolution clauses create challenges. Because if you say the parties will settle amicably, that is a very loose way of asking who is going to be responsible for bringing in the result or the resolution to the procedural problem. And then now going through the different steps in the multi-tier as well. And also creating the timelines and who is going to supervise the timelines that the parties have agreed upon. If it is vague, if it is not enforceable, then we'll have all manner of disputes with the lawyers from both sides trying to ensure that they get out of it and their particular perspective at that moment prevails. So if there's also a default or there's a deadlock, ultimately, anything that is vague creates default, creates deadlock, and it is the parties who are going to pay for this. Of course, if it's institutional arbitration and it has the multi-tier, that may, and I think Dr. Faris has said quite a bit about what the ICC rules of 2026 have done. A lot of these questions are now being answered, but then the autonomy is eroded. Then the decision and every aspect of the dispute resolution process is managed by ICC. The others are catching up, but they're not that far behind.
Yes. So if you want to summarize what has been said by the respected panelists in drafting dispute resolution, clarity is the key. Yes. And the method, dispute resolution, and the understanding of the subject matter of the contract itself, it helps. And of course, it's all under the principle of good faith that the parties must follow.
Okay, great. Thank you. Thank you, Dr. Amira. You've summarized it well. I don't think I can say more. I think the first question, when you're drafting a cross-border contract, it's important to understand the nuances of the jurisdiction that you are operating in. If I'm talking about East Africa, the truth is East Africa has now 8 countries, and we all have our legal jurisdictions, and there are nuances in each of those jurisdictions. So it's important to ask yourself, if there's a legal question that will need to be answered, how is it going to be answered, and which is the best place to have that answer emanate from? I think that is the first most important question that the parties must ask. Thank you.
So thank you so much, Jacqueline. This was brilliant. Because we have to close now the discussion. I see that there is no questions. If we want to have a takeaway from each of our respected panelists, 30 seconds each of you. If you have only one takeaway in drafting the dispute clause, which one would you pick? If any.
Okay, where would I start? I think in 30 seconds, I can say, ask yourself, you have to ask the questions. And the most important one is, which law governs this contract? Which law governs the dispute, if a dispute arises? And then you ask yourself, how does this affect my commercial bargain? Are there any surprises? That is the most important question you have to ask yourself. Are there any surprises that are going to be found if I choose a particular seat? And is there a seat that would work better for the commercial bargain that I may have chosen? So I think that would be my take home to anybody. Please ensure that you're being deliberate about how you're drafting this contract.
Faris?
I would definitely advocate for arbitration still. I'm very passionately pro arbitration, and I would invite people to, as Jacqueline said, to be very deliberate about their choices, and particularly to think about the correlation between applicable law, institution versus ad hoc, law of the seat, the place of the contract where it's being performed, and the lawyers that will end up representing you and be best placed to represent you, and the members of the tribunal. All of those things have linkages, one to the other, and in different formats and different correlations. And I invite people to engage in that process of looking at the consequences of choosing one and the impact that it has on the other.
Thank you, Faris. Karim?
So if I were to leave the audience with one final thought, it would be that the arbitration agreement should be drafted to operate effectively in practice, not merely in theory. And this means making the fundamental procedural choices clearly, ensuring that any pre-arbitral mechanisms are workable in practice, and tailoring the dispute resolution provisions to the structure of the project at hand, or the transaction at hand, and applicable legal framework, of course. So that's my
takeaway. Jean-François?
Very briefly, because everything has been said, but if I have to add one word, in addition to clarity, I think add simplicity, as echoing what Karim has just said, because things can look clear and not pathological, but they don't work because they are too complex. And when you get to implement them, you are stuck in difficulties that you have not suspected. So simplicity in clarity.
This is very, very complimentary and very important. So clearness and simplicity. So this was really a very helpful and genuine practical conversation. Thank you all. Thank you to Faris, Jean-François, Jacqueline, Karim. there is one thread running tonight. It's that a dispute resolution clause is not a boilerplate to be copied and reproduced without having great details, for each details. It's a design choice, and the caretaking at the drafting table is what decides whether it serves you later. So think long term always. That gives us a rich picture of how much rides on the drafting table. So this was the first of 3 sessions. On 17th of July, we turned to dispute avoidance and management, and on 20 July to enforcing awards from contract to cash. Details and registrations are on the SOS pages, and I hope you will join us there. Our thanks to the SOS Arbitration and Dispute Resolution Center and to Professor Emilia Onyema. Good evening to all of you. Good evening.
Thank you.
Thank you,
Amira, Emilia.
Thank you.
Very
Thank you,
interesting.
Amira. Thank you, Emilia. Thank you, everyone.
Thank you, everyone.
You're welcome. Emilia is not here, but she will be listening to all this.
Thank you.
thank you very much, Amira. Thank you all. Thank you.
Thank you all.
Thank you.
Take care.
Thank you.
Good evening. Bye.